Good morning, everyone, and welcome to episode 12 of our on-site construction webinar series. We've got a packed agenda today, but there will be an opportunity to pose questions of the panelists, and you can do so by using the Q&A function at the bottom of the screen. If we don't get to your question today, you can certainly follow up with us and the panelists. So without further ado, I'm going to introduce you all to our first speaker, Ryland Ash.
Thank you very much, Rebecca, and good morning, everyone. Thank you for joining. So the topic of today's session from me is records, and broken records. The records are the key part, and I will be the broken record. Now, why is this so important? Well, Max Abrahamson summed it up neatly in his book, Engineering Law and the IC Contract, where he said a party to a dispute will learn three lessons, often too late: the importance of records, the importance of records, and the importance of records. And of course, records will be not only important in the context of arbitration, but in the context of projects more broadly. So let's start with the basic question: what records should parties keep? First of all, I think it's important to say that these days there is a huge amount of data that's collected in respect of all aspects of a project, but not all of those records will be useful. The key thing is that the records that you collect are relevant and specific. Now, what do we mean by that? Well, what we mean is it depends what the type of contract is, depends what the contract requires, and it depends what the parties may need to prove later. I'm looking at this from both perspectives in terms of employers, main contractors and subcontractors, up and down the supply chain. So the key types of records that I'd like to see in most cases are minutes of meetings, discussions. Whenever you have a meeting or have a discussion and you come to an agreement or you have a very clear position, it's fundamentally important to make a record of those discussions. That doesn't necessarily have to be an email, but an email is very useful because it gives the other side an opportunity to respond immediately. Records of your own are, of course, useful, and contemporaneous records in particular will have the most weight. And that's a theme that I'll come back to. But the other thing is, if a record's going to be useful, it needs to specify the dates, times, and people involved. In relation to daily diaries, for example, and notes, site diaries, they need to specify the activities that those individuals and or groups or gangs are actually engaged in. It's no use having daily diaries and records showing the people who are on site without telling us what they were doing. They effectively become valueless. If you're taking photographs and videos, fantastic. That's arguably the best type of evidence because a picture paints 1,000 words. But again, they need to be dated and they need to be in context. Pictures of random parts of a construction site without other information is also relatively useless. Now, why is this so important now? Well, one of the key reasons is that the Building Safety Act requires a golden thread of records in the case of higher risk buildings in particular. And there's a full list in Schedule 1 of the high risk building regs. But what this means is that after the event, sometimes even up to 30 years after construction, the parties will need to demonstrate a number of key things, including, for example, registration records, certificates, reports, as-built drawings, and safety critical information. Now, many people will be talking about the use of AI and digital records being required, and things like BIM, Building Information Modeling. All of these things should be fed into the construction contract terms at the beginning, and my real estate partners will be talking a bit more about that later. So there's four key issues here as I see it. You've got progress and access records, change records, which include variations and compensation events, delay, loss and expense, and then, of course, notices. Taking progress and access first, the key point here is do not trust interim assessments. The reason I say this is because they are common on almost every infrastructure and construction project, but they are not necessarily final. In fact, they will not be final in almost every case of a standard form contract unless terms are added to that effect, which they very, very rarely are. So all that means is these are sort of interim assessments which can be opened up later in a final assessment. Now, what that means is if the parties disagree later, they'll have to prove what actually happened, even though you've got assessments that may not have been questioned at the time. In terms of the different types of interim and progress assessments, that will depend upon the contract. In some contracts, you're measuring against the bill of quantities. In some, it'll be the schedule of works, and in others, it'll be the activity schedule, for example, under the NEC contracts. But the same principles apply. You need evidence which tracks progress on site. In lump sum contracts, of course, contractors and subcontractors only need to prove that they've undertaken the works in the scope. Whereas if you've got a remeasurement contract, you'll need to prove the measure. So that the quality of records in terms of a measure is even more important if the measure is then questioned later, which is often the case. So the best type of evidence in this context is photographic video with context and timings, daily records of plant materials, names, timings, and activities. And if you've got site managers and project managers on site, they should be taking notes not only of the progress, but also of access issues, change issues, instructions, and records of what actually happened on site each day. When we're looking at changes, variations, and compensation events, first of all, you start with the contract terms. Does the contract require things verbally? Does it recognize verbal instructions or not? Or does it have to be in writing? If the contract says an instruction or change has to be in writing, then that's the rule. There will be no entitlement to any additional payment for additional works if you don't follow the contract. A CVI is confirmation of a verbal instruction. If the contract talks about that, make sure you follow these processes. Otherwise, these changes may not be recognized later. And does the person issuing the instruction even have authority to issue it? If they don't, it may not be valid. So the important thing here is clarity. When these instructions come in, clarify the meaning, clarify the authority, and make sure you follow the process. Now, the type of records to substantiate claims for changes, variations, compensation events obviously depends upon the form of contract. Is it lump sum? Is it remeasurable? But essentially, you have two kinds of change. You have changes that are valued in accordance with value, that is to say, the values agreed by the parties. And that's to an extent easier to demonstrate because you just show that the volume of that work and then it's valued in accordance with the rules under the contract. For example, under the JCT contracts, you could use contract rates. By comparison, if you're looking at NEC and FIDIC contracts, you're often looking at the cost. Now, the cost is obviously the cost reasonably incurred in relation to the issue. So the burden there is much higher. In terms of cost, you need obviously fact timing of the instruction, the impact compared to before and after, and then the additional work, whether that includes design, labor, plant and materials. Make sure you keep good records of every single stage that happens as a result of an instruction. And the specifics are listed out here really as a checklist for you later, but we're talking about evidence of comparable rates, proof that it's been incurred, invoices, bank statements, personnel signing in and out sheets, day work sheets, diary entries, and so on. There's an important reminder here in this case of the Attorney General of the Falkland Islands in 2003, where effectively the contract said that you must keep contemporaneous records, that is, records at the time things happen. And in this case, they hadn't, and they couldn't fill in the gaps, as it were, with evidence created later. And therefore, in this case, in relation to those records, the court rejected those claims. Now, in terms of delay, often that will follow on from a change or an instruction. The evidence is slightly different. With delay, you're looking at the impact of an event on the program. And of course, that would require a basic or baseline program that has been prepared prior to this and may even be incorporated into the contract in the case of the NEC forms. Essentially, what you've got to do is show on the balance of probabilities that an event A is covered by the contract and B caused the delay that is being claimed. But it's not just the cause, it needs to be critical. It needs to actually have an impact upon the overall period for the contract, or if you have sections, the sectional delay. So what you need, again, is you need contemporaneous records showing the attendances. Again, photos and videos are fantastic. If you're claiming for blocked access, please provide evidence of it. Emails notifying that the event happened. And another reminder here from a very famous case, Walter, Lillian Mackay, certainly in construction circles, where the court said that a sophisticated, contemporaneously maintained system for recording cost data in relation to delays was especially useful. And in that case, the contractor was successful because they had that quality of record. So there's two consequences for delay. You've got an extension of time and or loss and expense. So how do you deal with loss and expense? Well, I will say this, it's the most difficult to prove because you have to demonstrate what you would have reasonably incurred had it not been for the event, and then compare that with what actually happened. And most parties fall down because they simply don't have quality records of what they intended, nor of what actually happened. But this isn't a particularly difficult thing to do. What you should be doing, and in theory you could require this under the contract, is to set these things down at the point of execution of the contract and then measure against them regularly. Now, if you're a contractor, I would say you need to keep these things close to your chest until you need them, because often this evidence can be used against you. So think about this tactically. But essentially, in a disruption case, what you're looking to show is by way of contemporaneous records, had it not been for the event, you wouldn't have incurred the extra resource or expenditure. Now, it's important to remember that loss and expense doesn't always occur in a period of prolongation. In a period of prolongation, you can claim for prolongation or extended preliminaries, often costs, but you can also claim for disruption within the original contract period if your resources have exceeded what you would have otherwise incurred because of a material impact on the works. But you need to prove this material impact, and that's where your records will come in. In terms of notices, I have to follow on from all of these events with the requirements in the contract. If you don't issue notices in a timely and valid fashion, under some contracts, it will be a condition precedent to entitlement, which means even though you've created fantastically detailed and accurate records, your claim will fail because you simply didn't notify it in time. We have seen some bizarre provisions. For example, under an amended FIDIC contract recently, it required overseas service of all notices. And it's important to remember that notices are not just about delay, they could be about payment notices, payment applications, pay less notices, which could obviously lead to other problems such as smash and grab adjudications. So make sure you check the terms properly. Obviously, if you're pre-contract, agree terms that suit you. Think about the rules of service. In England, we have something called the postal rule, which means that you have deemed service after you've posted something. But the contract can specify these things. And think about public holidays, for example. Are they excluded? So essentially, issue these from day one. Do not wait. Don't worry about the feelings of the other party, because the fact is you both signed up to a contract and you're grown-up commercial parties. You should be able to deal with this. You need to protect your position from as soon as possible. You've got to set out the impact and continually update the other side. I think that's a very important step that people tend to ignore. And don't over quote contract clauses in these notices. It's not necessary unless the contract's very specific about setting out the grounds, which they often aren't. Just keep them simple. Even the background doesn't need to be necessarily detailed because the fact of the event will come out later, whether you can prove it or not. And finally, obviously, you may have other notices that might be relevant, such as termination, which of course would be absolutely critical. So my key takeaways in terms of records and myself, Mr. Broken Record, is that contemporaneous is king. The evidence created at the time will have more probative value and it would be more likely to be accurate. Always issue minutes, correct other people at the time when things happen, because it's very difficult to say later that you disagree with something that happened previously. Record agreements and discussions. Ask for all records, such as CCTV footage, for example, showing on and off site, drone images, and so on. Track your invoices and payments against specific activities and make sure they're collated in that way. That will save you a lot of time and effort later if there's any question over the value of the works. And finally, remember the limitation period. You need to keep these records. Previously, it was for 6 years from practical completion or 12 years if a contract was signed under deed. It's important to remember the Building Safety Act has extended this to 30 years in certain circumstances. So you need to keep these records well organized for a long period of time. And finally, the key thing to keep your house in order is to get regular high-level legal checks undertaken on your projects to avoid problems later. That concludes my whistle-stop tour of records. I will now pass over to Jamie Bell, and thank you very much for listening.
Thank you very much, Ryland, for that. So the Gateway regime is one of the most significant changes introduced by the Building Safety Act. The regime is designed to ensure safety, transparency, and accountability at every stage of a building's life cycle. Yet in practice, navigating these requirements is proving challenging with major delays for higher risk buildings. Failure to manage and mitigate delays during the Gateway regime can lead to costly delays in the project and potentially significant legal consequences. Over the next 10 minutes, I'm going to talk through the Gateway regime. We'll start with a brief overview of the three gateways and then focus on some practical steps and key considerations needed to manage risk and mitigate delays in relation to the Gateway approvals. So let's start with a brief overview of the Gateway regime. The Gateway regime is a three-stage approval process that applies to all higher-risk buildings in England, specifically buildings of at least 18 metres or at least 7 stories. The regime covers both new build projects and remediation projects to existing high-risk buildings. The three gateways are Gateway 1 planning, Gateway 2 pre-construction, and Gateway 3 completion / occupation. So Gateway 1 applies during the early planning phase of a project. As part of the planning application, developers must submit a fire statement demonstrating that key fire safety considerations specific to the development have been addressed. The Health and Safety Executive will review this statement and provide advice to the planning authority. In short, high-level fire safety considerations must now be embedded from day one. Moving on to Gateway 2. Gateway 2 marks the pre-construction phase and introduces a true hard stop. Construction cannot begin on site until Gateway 2 approval is granted by the Building Safety Regulator. At this stage, the Building Safety Regulator, not the local authority, must approve the building control application. The application must provide detailed evidence that the proposed design and works fully comply with the building regulations. The key duty holders, the client, the principal designer, and the principal contractor are involved in inputting and submitting the Gateway 2 application. Now let's talk about the issue everyone in the industry is experiencing right now, timing. Under the Building Safety Act, the Building Safety Regulator is formally allowed 12 weeks to approve the Gateway 2 application for new construction and 8 weeks for works involving existing building. In reality, approvals are taken on average around 40 weeks due to a backlog in the regulator's processing capacity. The consequences are serious: stalled projects, extended programs, and escalating costs. These unplanned delays are also triggering disputes over liability for both time and cost overruns, making proactive planning and risk management essential. However, it's certainly not all doom and gloom. The government are well aware that they need to tackle these significant delays. A newer chairman was appointed earlier this year to break the logjam. The regulator is scaling up capacity, and in October, it released a public statement stating it aims to complete a significant amount of legacy applications by the end of this year. Obviously, whether they hit this target considering the issues to date remains to be seen. Moving on to Gateway 3. So Gateway 3 is the final checkpoint before a building can be occupied and occurs at practical completion of the development. The client must evidence showing that the construction matches the approved Gateway 2 design and complies fully with the building regulations. This includes any updated plans and additional prescribed documents relating to the as-built of the building rather than the as-designed. The building safety regulator will assess the application, carry out a final inspection of the building, and if satisfied, issue a completion certificate. In relation to the proposed timelines for Gateway 3, the building safety regulator has 8 weeks to approve a valid application. However, similarly with the Gateway 2, we are seeing delays with the Gateway 3 approvals as well, with some estimates coming in around 4 months to obtain approval. And because so many projects still remain stuck in the Gateway 2 approval process, there's currently a lot less evidence on the Gateway 3 performance. So this only serves to add an additional layer of uncertainty for the industry around the program, etc. So now that we've explored delays with the Gateway regime, it's now time to shift the focus to maybe some solutions and actionable steps to manage and minimize delays. Good news is that there's many risks, there's also many ways to factor to manage these risks with proactive steps taken early in the process. So one of the most effective and probably simple ways to manage the risk is ensure you assemble the right team from the outset. Early involvement of experienced professionals, designers, and contractors can prevent costly mistakes and keep approvals on track. Of course, there may still be delays by the third-party regulator, but making sure all applications are submitted correctly will minimize any further delays. Another critical step is appointing a building regulations principal designer and a building regulations principal contractor as early as possible, with their responsibilities clearly defined in the contract. This ensures accountability of who's collating and storing the golden thread information, as touched upon Ryland earlier, who's contributing to the design at each stage, and who's monitoring compliance with the building regulations. Another key nuance that not everyone is aware of is the CDM principal designer and CDM principal contractor are not the same as the building regulation principal designer and principal contractor. Despite their very similar titles, they cover different regulations and essentially have different disciplines. So you need to make sure that those roles are separated out and it's clearly set out in the contracts. Under the Gateway regime, the client now plays a pivotal role in the process. Ultimately, the client must sign off on each application at the stages, and they must provide formal statements such as they've appointed a team which is competent and to the best of their knowledge, the works comply with the building regulation. This responsibility cannot be delegated or subcontracted. While certain tasks can be assigned to others, the accountability for these statements rests with the client, which serves as a significant shift from the previous practice. As mentioned earlier, this is causing considerable concern for clients who may not be involved in the day-to-day running of the construction project, and then they're suddenly approached at the end to make wide-ranging statements which they may not feel comfortable with unless they've seen the correct information. Because of this, we are seeing more clients appointing a dedicated building safety advisor. This bespoke role is separate to the principal designer, involves a client representative ensuring all the correct information is collated to enable the client to confidently make the required declarations. Maybe they prepare checklists of all the information, etc. If the information is then not correct or accurate, the client would then at least have recourse against that advisor. So moving on to mitigating some of the risks and managing them. Now let's discuss the procurement strategy, because the route you choose can also have an impact on managing gateway delays. Of course, the contractor can't actually start any works on site until the Gateway 2 approval is obtained. So a procurement route that could be utilized is the two-stage procurement process, with the contractor being engaged under a pre-construction services agreement during the Gateway 2 approval period. The contractor then enters into the main contract upon the Gateway 2 approval. The design and Gateway 2 will be completed before the main contract is entered into, and the contractor will have time to understand the employer's requirements and risks on site, which could go some way to de-risk the building contract. However, the PCSA does need to be drafted robustly to deal with any issues such as transfer of design if the contractor is not appointed under the main building contract and another contractor is utilised. Another critical issue is how the gateway-related delays are dealt with under the contracts. Contractors are understandably concerned about exposure to liquidated damages and who is to take the risk for any delays to the completion due to delays in approval by the third-party regulator. We're seeing several contractual solutions emerge. One approach is adding a new extension of time trigger and loss and expense trigger for delays caused by the regulator. Another is introducing sectional completion with separate sections for Gateway 2 and Gateway 3 approval periods. These sections don't attract LADs, while sections covering the actual works and submission obligations still do. From an employer's perspective, building safety regulator sign-off, such as the Gateway 3 sign-off, should be a condition for practical completion to ensure the contractor is incentivized to deal with any issues raised by the building safety regulator during the approval process, and to ensure a PC is achieved. This should help minimize any delays with sign-off. As delays to Gateway 3 and Gateway 2 approvals can add over a year to the program currently, another common concern that is arising for high-risk buildings is inflation. Extended approval periods can push projects into different cost environments, creating real pressure on budgets and margins. Contractors could push for inflationary or cost fluctuation provisions in the contracts to take into account these inflationary pressures. Therefore, to help manage the cost of these delays, it's important to understand how inflation is factored into the contract price. If the contractor is pushing for fluctuation provisions, any mechanism to calculate these increases should be pre-agreed and clearly described in the contract to avoid any confusion or disputes down the road. To conclude, the Gateway system marks a fundamental shift in building safety regulation. It introduced higher standards, early scrutiny, and significant more transparency and accountability for all parties involved in the construction project. Whilst there are ongoing significant delays with the regime, careful planning, early appointments, competent teams, and clear contracts can proportion responsibility and any delays, which can then significantly mitigate the risk of delays. So thank you very much for listening, and I will introduce you to my colleague Barry Hembling, who will deliver the next session.
Thank you very much, Jamie. So in the next session, we're going to look at contract themes. So over the last year, we've been looking at a lot of construction contracts for clients. And this is an area I've been thinking about, in particular, having updated this year 2 books for LexisNexis on construction precedents. I'll speak about that at the end of the presentation. But as we look at the contracts that we've reviewed over 2025, you can see certain themes emerging. So I thought I'd just deal with those in this presentation. So the first theme that I wanted to just give you an overview on is basically some of the points that we've been looking at in particular. I think the Building Safety Act remains the key influence. We're seeing contracts being updated to accommodate alternative procurement methods. There are new contracts coming to the market, such as in relation to the JCT target cost contract and alliancing contracts. Contracts have been updated to respond to new technologies, and there's also new pressures around sustainability targets. So overall, we're seeing more clauses incorporated in construction contracts, but less willingness to depart from a key set of market standard key issues. So what is basically market standard in 2025? So these are the core issues that funders in particular will consider as part of a real estate finance transaction. And a starting point for any employer will be, can they obtain finance for the job? sometimes known as bankable principles. The absence or presence of these clauses can make a real difference as to whether funders are willing to lend on a project, and if so, on what terms. They will also determine whether that funding transaction completes within a shorter or longer duration. And they cover issues such as those on the slide: reasonable skill and care, intellectual property rights, timescales for bringing claims. So I think the first key lesson to take away is for employers, funders, you'll want contracts that align with market standard expectations, not only for funding, but also for long-term view about the sale of the asset. Contractors, consultants, they will have greater freedom to argue about many of the commercial or contractual points, but they'll struggle to secure significant departures from these core principles. And the difficulty for everyone involved is that these core bankable issues, they keep changing according to market trends. So it's important to take professional advice to ensure that your expectations and contracts are up to date. The second theme that we're seeing incorporated into construction contracts in 2025 is digital technology and integration. So we have issues like BIM, so increasing use of BIM on projects, and issues there that arise include the appropriate BIM model to be followed, the requirements and expectations regarding BIM, who has custody of the model, the responsibilities for coordination. We're seeing the use of AI on projects now, and there's several problems that can arise in that area. For example, was the AI at fault due to flawed data or the AI hallucinating, or was it due to inadequate training or methodology or hardware issues? And all of these could be points where a contractor or consultant may be liable. And Ryland mentioned earlier the golden thread of information, that digital record to be kept about a life cycle of a building. So there are a lot of themes coming together there about technology and digital integration that need to be dealt with in construction contracts. So I'd say the key theme on this one is that all parties will want clarification on roles and responsibilities if something goes wrong. Generally, in terms of technology and digital integration, I'd say this is an area where we've seen a lack of detail, and it would be beneficial if there was more detail, particularly around roles and responsibilities about who should be doing what. The next theme that we've been seeing over the course of this year is drafting around sustainability and environmental concerns. So there are obviously increasing sustainability targets, and these have two main drivers in the market. We have BREEAM, that science-based third-party certification system for verifying the sustainability of buildings and infrastructure. And we're also seeing the growth of green leases, which are becoming increasingly popular in the commercial property space. And there are leases that have clauses encouraging the landlord and tenant to collaborate on improving environmental performance and reducing energy consumption. And as a result of those drivers, we're seeing increasing drafting in the construction contracts. In terms of the key themes, I think much of the drafting that we've seen to date has been aspirational. So it's given the optional choice for contractor or the consultant to propose methods that are beneficial to the environment or the long-term sustainability of a building. However, I think what we may see is those requirements becoming less aspirational and more prescriptive. So only this week, for example, we've seen the launch of a new ISO 17298. So that's the first global standard focused on biodiversity. And that standard provides an auditable framework for organizations to assess, manage, and report their impacts on nature. So I think this is definitely an area that we should keep under review, watch as we go into 2026, and see whether some of that drafting moves from being aspirational to more prescriptive. Moving on to liability clauses in the market, it remains the case that there's no standard position on liability, but I think some themes are emerging. So there seems to be an increasing acknowledgement on the part of funders and employers that contractors, consultants will want to set their liability at a defined level and that arrangement generally tends to be agreed where that cap is sensible. We're seeing net contribution clauses remaining challenging to negotiate. So they're not being accepted by employers or funders generally. So they're clauses, you may recall, which apportion liability between two or more parties responsible for the same loss. But what we are seeing are compromise clauses known as loss of contribution clauses becoming increasingly popular as a way of providing a compromise position between no drafting around multiple parties responsible for the same loss and the net contribution position. Key themes emerging here. So I think liability caps can be agreed where they are set at a sensible level, taking into account the size of the project, the works or services being provided, and the availability of insurance. Where there's a desire for drafting about multiple parties being responsible for the same loss, consider the loss of contribution drafting in the event that the net contribution is not agreed. And I think it will be in everyone's interest for there to be clarity in the contract about the timescales for bringing claims. Obviously, employers, funders will want the latest possible position to be agreed. Contractors, consultants will clearly argue for an earlier date. The last theme that I wanted to touch on is dispute resolution. So I'd say in this area, we're seeing increasing demand for drafting around collaboration and dispute escalation ladders. So that seems to reflect a theme in the market. The parties want to try and prevent disputes. And that drafting has been a feature of many construction contracts for a while, particularly the NEC. But regardless about the drafting regarding collaboration dispute escalation ladders, it's still important for contracts to include clear drafting about what happens if disputes do arise. So in terms of arbitration, we're also seeing that's becoming a more attractive and efficient method of dispute resolution. I think there are several drivers for that. We've seen lengthy delays in the court for civil claims. We've had a refreshed Arbitration Act this year with the Arbitration Act 2025 coming into force. And there are also international and economic legal trends which favour arbitration as well. Finally, where collateral warranties are concerned, it would be remiss of me not to mention adjudication clauses in collateral warranties to address the Supreme Court's position in Abbey and Simply, which clarified that statutory adjudication rights will only be implied into collateral warranties in limited circumstances. So I think in this area, it's in everyone's interest for there to be well-drafted dispute resolution clause. That clause must set out the clear timescales, what's to be done by when. For example, it would want to cover contractual, non-contractual claims. If there's an arbitration clause, will the law of the contract cover the same law as the arbitration proceedings? So in conclusion, any drafting in construction contracts should respond to the complexity of the project. Simple projects should lead to simpler contracts, more detailed versions for larger, more complex developments. Contracts continue to evolve to provide clear and fair allocation of risk between parties. We've seen, for example, the JCT target cost contract that was published over the summer. And would also need to see liability becoming more accepted. Perhaps we are moving towards more market standard positions on that, and a greater desire for timescales for bringing claims and dispute resolution. In terms of, if you want to know more, I updated the LexisNexis UK Encyclopedia Reforms and Precedents Construction Edition this year. And then next month, there's another book coming out, Manual of Construction Agreements, that contains a whole other series of precedents. Thanks very much. I now hand over to Theresa, who will give us more of an overview about 2025.
Thank you very much, Barry, for that introduction. So I'm going to give you an abridged version of our 2025 in perspective. You may have noticed this was published very recently, the On-Site Review 2025, and that covers market trends, economic drivers, key legal developments, building safety reforms, contract risks, and what lies ahead for the industry. Now, I'm going to focus on key legal developments. Now, what we've gathered together are a collection of the key cases. So Abbey Healthcare, as Barry just mentioned, URS Corporation and BDW Trading, Triathlon Homes, and Grey GR Limited. Now, I don't think I'll get time to touch on Grey GR Limited, but that will be in the slide deck for you to look at later. Now, Barry's given me permission to talk about Abbey Healthcare. Of course, if there are any detailed questions, please direct them to Barry. Now, just to recap, in case you're unfamiliar, this case concerned a luxury care home in Mill Hill, London, which was designed and built by Simply Construct. Now, after opening, significant design and construction defects were discovered, including fire safety issues. The contractor failed to carry out the remedial works, forcing Toppan and Abbey to undertake repairs and incur substantial costs. Now, the judgment followed long-standing litigation between the parties over how the claimant's business losses should be recovered. This judgment finally compensates the claimants for their business losses. It also provides helpful guidance, especially on the issue of lost trading profits claims and lost transaction claims, highly relevant to clients operating in the sector. Now, the case is considered landmark for several reasons. Barry did touch on one just now. But first of all, there were Abbey's loss of trading profits. So Abbey's trading profit loss was assessed by comparing actual profits with those that would have been earned but for the contractor's breaches. The judge found that Abbey had to limit occupancy from September onwards due to defects, with repairs carried out carefully to protect residents. The court confirmed that Abbey should have been put in the position it would have been but for Simply's breaches, comparing actual profits with hypothetical but for profits. Now, in terms of abortive legal costs, the legal costs incurred by Abbey on the abortive transaction for the sale of the care home were held to be losses caused by the contractor's breaches of duty. These costs were aborted and wasted, as any future sale of the care home would require the new work to be carried out. Overdraft charges. Now, Abbey claimed additional overdraft costs because remedial works delayed occupancy and reduced expected income. Now, the judge held that these losses were too remote and unrecoverable, as the contractor had no knowledge of Abbey's funding arrangements or overdraft facility at the time of contracting. Lost sale claims. So although such losses can be recoverable if contemplated at contract formation, the judge held that no award was due. While the sale failed because of defects, any loss to Toppan would have been offset by support it would have provided Abbey to compensate for higher rent under a new lease. Now, I think that any sort of review of this year would be a bit remiss if it didn't cover URS Corporation and BDW Trading Limited. Now, this is a landmark case again that confirms that developers can recover costs even after selling properties. It expands the scope of duties and limitation periods. Now, the Supreme Court's ruling here basically addresses a whole series of problems. Now, to give you a bit of background, BDW voluntarily undertook remedial works on developments it no longer owned. This was a big part of the case. Now, it incurred significant costs to address defects linked to URS's negligent structural design. Now, URS argued these costs were irrecoverable because BDW acted voluntarily and had no enforceable obligation. The court rejected this, holding that there is no voluntariness principle preventing recovery where the expenditure addresses real fire safety risks. Now, this was really important in this case because there was a huge argument that, well, did BDW really have to do all this work? And we'll come on to that point in a moment. The judgment also clarified the retrospective effect of Section 135 of the Building Safety Act, which extends the limitation period for Defective Premises Act claims from 6 to 30 years. So that links back again to what Ryland was saying about keeping records. You can imagine that if the limitation period is extended so much, the documents and the records that you'll need to have had to try and address any of these sorts of points. Now, this extension applies not only to direct DPA claims, but also to negligence and contribution claims dependent on DPA limitation rules. The court further held that duties under Section 1.1 of the DPA extend to developers who order construction, and contribution claims can be pursued without prior judgment or settlement, provided payment has been made. Now, I think that's a really important commercial point, certainly for parties who are trying to deal with things proactively and quickly. Now, just to get into the practical implications of this case, this decision reshapes risk management in construction. Developers can now recover costs for voluntary remediation even decades after completion, and liability can persist long after projects are sold. The court emphasised, and this is the point I meant about the voluntary nature of the work, BDW's actions were not truly voluntary. They were driven by potential liability for injury, reputational harm, and moral responsibility once defects were discovered. Now, this interpretation encourages proactive remediation and aligns with the Act's policy goals. For the industry, the implications are profound. Extended limitation periods mean historic projects remain exposed, and contribution claims can cascade up the supply chain. Contractors, consultants, and developers must revisit their contractual risk allocation and insurance strategies. The ruling reinforces accountability and signals that courts will prioritise safety over technical defences, ensuring those responsible for defects bear the financial burden. Now, just very quickly, I thought they might be difficult with time. I just need to touch on Triathlon Homes and Stratford Village. Now, Triathlon Homes, you've probably heard about this case a lot. They sought a remediation contribution order against Stratford Village Development Partnership and its parent company Get Living PLC to recover over 17 million in remediation costs for East Village blocks. Now, the developer in this case argued that it was unjust to impose liability because public funding had been secured and claimed that RCOs should not apply to costs incurred before the Building Safety Act came into force in June 2022. Now, these arguments raise fundamental questions about fairness and the retrospective nature of the Act. Now, the Court of Appeal dismissed both grounds. It's held that public funding does not shield developers from liability. The Building Safety Fund is a last resort, not a substitute for private responsibility. The court also confirmed that RCOs can cover historic costs, interpreting Section 124's reference to costs as incurred or to be incurred, as evidence of Parliament's intent for retrospective application. This interpretation ensures leaseholders who have already paid for remediation are not left without recourse. Now, the practical implications of this are the court's reasoning reinforces the principle that developers and their associates sit at the top of the liability hierarchy. The judge emphasised that the public should not bear the cost of fixing defects when developers and their corporate groups have the means to pay. The judgment also signals a readiness to pierce corporate veils, making parent companies liable even if they did not directly develop the building. This approach curtails the use of thinly capitalised SPVs to evade responsibility. Now, this decision has wide-reaching implications for real estate and corporate transactions. Buyers of residential portfolios must factor in legacy building safety risks, and group structures will face greater scrutiny. Combined with the Supreme Court's ruling in URS and BDW, this case confirms that liability for historic defects is both retrospective and expansive. Developers can pursue upstream recovery under extended limitation periods, but they cannot avoid primary responsibility. The message is clear: accountability for building safety is non-negotiable. And just to finish off my section, I'll just give you a very quick update, very timely development on this case. On the 6th of November 2025, the Supreme Court rejected SVDP's application for permission to appeal on ground 1, so that was the exercise of the just and equitable discretion, but granted its application for permission to appeal in respect of ground 2, retrospectivity in respect of Section 124 costs. So this appeal will be heard by the same panel that will hear the appeal in Adriatic land, so we will keep you posted. So on that note, just very conscious of time, I will hand back to Rebecca.
Thank you, Theresa, and thank you to all of our speakers. We do have time for some questions. We have quite a few. I'm actually going to choose my favourite question. And I think this is really a question for you, Ryland. I love this one. Are WhatsApp messages admissible? And I say that because I think that they can be a treasure trove for disputes lawyers. So yes, that's a question for you.
Great. Thank you, Rebecca, and thank you for the question. I think I'd start probably with Rebecca Vardy and Colleen Rooney being in court in 2022. For those of you who don't know, Rebecca Vardy lost her libel case against Colleen Rooney, primarily because she claimed that she'd lost her phone at the bottom of the ocean. And I think counsel questioned her and asked whether the phone was in Davy Jones's locker, at which point she replied saying, I don't know Davy Jones. Um, Now, the key question there is, were these messages disclosable and or relevant? And the answer is that they were. And so, it doesn't matter if you're a famous footballer or a footballer's wife, you might be Thierry Henry, Dennis Bergkamp, or Arsene Wenger, or just a project owner or contractor. Um, WhatsApp messages are used, all the time by people, and they're often used in a way that is less formal. People say things that they shouldn't say. The ultimate point here is that they are disclosable unless they are privileged. So unless there is something in there that qualifies as legally privileged, such as legal advice between lawyers and clients, essentially they will be disclosable. And of course, they have to be relevant to the issues in question. So, yes, be very careful when you use WhatsApp or any other messaging system. And if you need to rely upon them, obviously you need a reliable backup as well. And keeping records of what was actually said in the context of those messages is also very important. But yeah, useful reminder to anyone using WhatsApp.
Thank you. I would echo that sage advice. So the next question, actually, this could be for, I don't mind who picks this up. What contractual provisions should lawyers include to ensure contractors maintain and deliver comprehensive compliance records for decades after project completion? Theresa?
Thanks, Rebecca. I was going to actually try and persuade Barry to answer this one, but I think that one of the express obligations requiring it in very clear terms would be my suggestion. Because I think one thing that we've learned from the cases we've just talked about is that what they're directing contractors towards is proactive risk management, demonstrating compliance with building safety standards, transparent structures and processes. So all of those things, if I was going to offer some advice, would be to have this prescribed as carefully and clearly as possible. So for whatever period of time it is, literally be express and make it a mandatory obligation. I mean, don't know if Barry, if you've got any other pearls of wisdom, but I mean, I think also just, sorry, to extend this, given the huge amount of time the new legislation is requiring and allowing for claims to be continuing, I think that you really is upon all of the players in this sector to make sure that these records are very safely kept and well organised.
I would agree with that entirely. It needs to be written into the contract, really needs to be clear as to how long the obligation is intended to last.
Thank you, both of you. Have a look. Okay, this is, are hotel developments included within the Gateway scheme? I nominate Jamie because that's obviously relevant to your talk.
Yes, thanks, Rebecca. Actually, I just note Joan Kennedy's just put a comment as well that's relevant to my talk in the chat. So thanks for that, Joan. You kind of highlighted that the CLC has published a comprehensive guide to support Gateway 2 applications. So yeah, this aligns well with what we discussed earlier around practical considerations early, particularly in relation to getting design information right and managing documentation. So for anyone preparing Gateway 2 applications, it's worth a read of that alongside the statutory requirements. But yeah, just to go back to your question you raised, Rebecca. So yeah, I mean, as a default position, hotels are excluded from the high-risk building regulations. However, and this is a big however, if there's 2 residential units or dwellings within that building, it may still fall within the high-risk building regulations and therefore the Gateway 2 regime. So it's certainly worth considering each building on the facts of that basis and making sure you're checking whether, for example, service departments within the hotel could fall within the high risk building regulations. You need to make sure you analyze each buildings on a case-by-case basis.
Thanks, Jamie, and thanks, Joan, as well for your input. I think we can squeeze in one more question. It's another drafting question. How influential are the 2024 JCT updates for the drafting themes you discussed, Barry, in your talk?
So I'd say those themes reflect wider developments in the market. I wouldn't say they've led the debate. There's been a some review as to the extent as whether they went far enough. So I would say they reflect some of the wider drafting themes, but by no means they've led the debate. If anything, some of the other contracts have been more influential. We discussed briefly the NEC and how you have the collaborative drafting and the dispute escalation ladders. That's certainly more relevant in terms of dispute resolution drafting than the JCT. If anything, the JCT has been catching up to reflect these wider trends, and they've moved some of the optional provisions around sustainability into the more prominent positions within the contract. But I think they've reflected wider trends rather than led the debate.
Thank you. Well, we have 2 minutes to go, which is I think we should probably wrap up now to keep to the time. I just want to thank everybody for joining us today and hope that you found it informative. As ever, a feedback form will be circulated, and we'd be very grateful for any comments that you might have, and indeed any subjects that you would like us to present on in future. That would also be welcome. And there's a recording of the webinar, and it'll be available on our YouTube channel next week. And if you dialed into the webinar, we'd be grateful if you could please email events@wfw.com just to let us know that you attended. Hope everybody has a really good day, and goodbye from all of us. Thank you.